Good afternoon, everybody, and welcome to our 2022 HR Potpourri presentation. This is Barbara Jennings, and I am here with
Corbin Granger. Hello, everyone.
And it's really nice to be here and be presenting on something other than COVID. I do have some slides that deal with some COVID information, but it's kind of nice to feel like we're getting back into the groove again. Just for a little background, I want to let you all know that, first of all, Corbin and I are not lawyers and we're not accountants. I spent over 30 years in human resources management, and I then have spent a couple of years in the insurance world. I've been a banker and have had a pretty varied career. And Corbin is our compliance officer here, and we work together as a team covering really all kinds of interesting projects. So I just wanted to give you a little bit of our background. I want to say something that some of you have probably already heard me say before, but you know, can you believe it's been 2 years since we embarked on this COVID pandemic journey? And over the course of those 2 years, I have talked to so many, probably of people that are on this line right now, and so many people who are trying their best to do good things in HR, and what a huge challenge it's been for you all. And it's been so gratifying to talk to people and to email people that are charged with managing all of the functions of a human resources department. And oftentimes, in addition, you have other duties as well. And it's been so impressive, the fact that most of the time, people are just trying to do the right thing, trying to get good information, trying to make good decisions for their employers. And so I really would give all of you a shout out as really the unsung heroes of the pandemic. Anybody who's had to deal with human resources, you guys have just done an incredible job, and you just give yourselves a pat on the back for everything that you've been trying to do. So again, we've done our disclaimer about not being lawyers. I'm sorry, I'm adjusting to a new system here that I'm trying to not go, there we go. Disclaimer about the fact that we cannot render legal advice, we cannot render accounting advice, but what we do is we try to look at HR issues from a practical point of view. Whenever I talk to you in person, individually, the guidance that I try to give you is looking at things from a human resources point of view and a human resources management point of view. So that's where we're coming from today. There are going to be times when you need to contact a lawyer about situations that you've got going on. And I sometimes have to give people just that guidance and simply say, here's the way I analyze your situation. But if it were me as an HR person, I would seek the advice of an attorney. So sometimes you just, you'll find yourself in a position where you just have to do that in order to protect yourself and to protect your company. Now, what I did was this. You'll see this says the top 6 list. Sometimes we live in a world that likes top 10 lists, but what I did in putting this together was go back through all of my emails from the last, or all of my client emails from the last 6 or 8 months to see what type of questions have people been asking. And I culled 6 topics, again, other than COVID, which has occupied the bulk of the time, but I have come up with 6 things that I get questions about fairly regularly. So I thought that I would share that list with you. Now, for those of you listening, obviously, you might not have any questions about some of these topics. Some of these things you may not have ever even heard of, but these are things, questions and issues that people raise more frequently than some other things. If I had to pick one thing outside of COVID that people ask the most questions about, it would probably be FMLA. And today, this is not a webinar that's dedicated to FMLA, and so I'm just going to cover a couple of areas that cause people problems once in a while. Obviously, if you've had to deal with FMLA, you know that it's complicated, you can make a lot of missteps, and I do get questions on that regularly. But these 2 areas 2 or 3 areas that people ask me about on a regular basis. All right. First of all, just a real quick overview of what is FMLA. It's the legislation that entitles eligible employees of covered employers to take unpaid job protected leave for specific health related issues for yourself or for the employee and for some family members. So generally it provides up to 12 weeks of job protected leave in a 12-month period. Now you define your 12-month period, and this causes people confusion. It can be either once every calendar year. You can do it with a look back method. You can do it with a look forward method. So you define how you're going to calculate your 12-month period. 12-month period. My apologies if I said 12 weeks. And as long as you apply that consistently, you should be fine. And if you do want to change that, your 12-month period, you can do that, but you do have to give your employees notice that you're going to change to a different 12-month period. And you don't want to disadvantage any employee who is already on FMLA or who has already requested or you know that they need FMLA. Now, generally it's 12 weeks, but if you have certain military circumstances, then you may get up to 26 weeks. And frankly, in my career, I have not come across a situation where anyone has ever asked for 26 weeks, but you do need to know that that's out there. The purpose is to protect your employees' health insurance coverage so that while they're out on a bona fide FMLA leave, that you do have to keep their health insurance in place and you do have to continue paying what you normally pay for their health insurance. The employee needs to pay what they normally pay. Now, again, in most of these laws, you can always be more generous than you're required to be. So you could say, we're just going to pay all of your health insurance premium while you're out. But most employers do require the employee to pay their portion. You do have a job guarantee in addition to your health insurance guarantee, so that you have to be restored to the identical position or the same position or to an equivalent position following your leave under most circumstances. Equivalent means same location, same pay, same seniority, same level of job duties, that sort of thing. And then what confuses a lot of people is the fact that the law says that FMLA is unpaid leave, and that is true from the law point of view. However, if your employees earn or receive vacation, sick leave, PTO, personal time, that sort of thing, the employer can require employees to use all of those leaves concurrent with their FMLA. So you can set that up as a policy, and you can require employees to use their vacation, sick leave, PTO, et cetera, while they're on FMLA. And then if they run out of that while they're on FMLA, then they would go on unpaid status. So that causes confusion when people hear it's unpaid, but then on the other hand, they're going to get paid, but only if they've got accrued leave, whatever policy you come up with. And again, that is something that you're going to want to apply consistently, and you don't pick and choose employees, and are you going to make them use it or not? You need to have that policy. And again, I always encourage you to put that in writing and make it part of your handbook so that employees know how their FMLA is going to be treated, before they even let you know they need FMLA. All right, another question that has been raised on numerous occasions is, what do they mean by health plan? You have to keep their health plan while they're out on FMLA. Basically, it means that the plan is offered by the employer. It is partially or fully supported by the employer in terms of premiums, and you pretty much you don't have to join it, but most employees do. It's generally speaking, your group health plan that is subject to FMLA is going to be your health insurance, your dental insurance, your vision insurance, and there are obviously other types of insurance that may be able to be continued under FMLA, but may not be required to be. All right, so again, I include a lot of information for you so that when this webinar is over, you can go back through and use this document as a resource, because we will be sending you copies of the slides by email. And then I've got a little chart here that you almost always, health plans would be health insurance, dental, and vision. Sometimes you're going to put your group life insurance in there, your group disability insurance in there, and then what is not required to be covered is going to be your voluntary reimbursement plans, like your AFLAC type plans. You're not required. So the question to ask are, does the employer contribute to the premium and is participation voluntary? All right, now another question that I get on a fairly regular basis is, what is a healthcare provider? And as you might imagine, this comes up when someone calls me and says, my employee brought me this thing to document their need for FMLA, and I'm kind of suspicious. I can't really tell what kind of practitioner this person is, this provider. And so just so that you will know, there is a pretty broad definition of healthcare provider, okay? It is not limited to doctors. It can be, the thing can be signed by a nurse practitioner, a nurse midwife, a clinical social worker, physician assistant, podiatrist, dentist, all sorts of things you can read there, plus more. If I had copied the whole section out of the FMLA guide and tried to paste it, I think it would have taken like 3 or 4 slides, because there's a lot to practitioner. If you have concerns about the provider, you might, Google is your friend. You can certainly Google it, try to find this provider. You can even ask your employee, is this, your HR department should do the asking, not the supervisor. Is this person a doctor or whatever? And just, if you have any, before you do anything negative toward that employee, I'd ask of legal advice before you just flat out say, no, I can't accept that, that documentation. All right, another thing that we get asked about from time to time is USERRA. Now that's the Uniform Services Employment and Reemployment Rights Act. Being in a military town, we periodically have people who go on periodic leave. And so I get some specific questions about what you have to do as an employer if one of your employees comes to you and says, hey, I'm in the reserves and I have to do this or that or the other. Just to let you know, just about every employer is subject to USERRA. Okay, so there's no size limit or any of that sort of thing. It includes all the branches of the service, and there is a poster that you are required to post in a conspicuous place, letting people know of their USERRA rights. But the USERRA questions fall generally into 2 categories. How do I pay this person, or do I pay this person while they're out on leave? That's probably not as big an issue back during the early 90s, and then again from 03 forward, you had probably a lot more people who may be called up for active duty. I know that in 1 or 2 of my employers during that period, we had a number of different employees of the companies that were called up to active duty, and how do you deal with those employees? USERRA does not require employers to pay their employees for any type of active military duty. Now, one thing you have to keep in mind is that if you know that there are different rules for hourly employees or non-exempt employees and for exempt employees. So the same exempt salary pay rules apply to people in the military. So let's just say that you have an exempt employee who for some reason goes away for 3 days of military duty, and they work 2 days that week and then they're gone the other 3. Well, if they're exempt, you need to pay them for that whole week because they did do some work during that work week. If they're hourly, you do not need to pay them for those 2 days, for those 3 days that they've been out with the military. So, 2 different, remember you have those 2 different classes of employees. USERRA does not require, again, that you pay non-exempt employees for military leave. You may offset the amounts that they receive from the military. Like you could, if they're out and they get paid some from the military, but it's not as high as their regular pay, you can go ahead and pay them the difference between what they receive from the military and their regular salary. You may allow them to use their PTO or their vacation benefits. You cannot require them in case there's like some type of gap when they're in, like they're traveling or something for military, and in order to keep them getting a paycheck and they say to you, I'd like to use my vacation for this period, they do have the right to use the vacation. And also paid leave accruals. If you typically allow employees on some other type of leave of absence to continue accruing vacation or PTO or sick leave, then you need to continue as though your military person had still been actively there at work. And then you're not entitled to use accrued sick leave during military leave unless the employer allows other employees on leaves of absence to use their accrued sick leave for non-illnesses. I think it's become more common over the years to have, for employers to kind of move away from the discrete vacation and sick leave plans into some type of combined paid time off plan. But in any case, you're not forced to let people use their sick leave if they're not sick. All right, how do I handle their benefits? This is a little bit more complicated. If the employee is covered under your health insurance, here's how you have to do it. If they're going to be gone for 31 or more days, then the employee may elect continued coverage. And I've had people do this because they wanted to be able to continue their family's coverage while they were out. So they are allowed to continue for 24 months, but they're not required to do that. They can be made to pay the premium, the 102%, just like you would with COBRA. And when they're reinstated, you must be reinstated immediately into the health plan with no waiting period or pre-existing condition exclusion. If they're going to be gone for less than 31 days, then the employee just stays right on the health coverage, just as though they were continuously employed. With their flexible spending accounts, there's this thing called the HART Act of 2008. It does allow reservists who are called active duty to use unreceived distributions from unused funds that might be in their flexible spending accounts without any penalty, and also not to forfeit under use it or lose it rules that apply generally to cafeteria plans. So basically, it's just a little bit more flexibility for people who are serving the country, and their schedule may be odd, and not to have them experience any kind of penalty for being in the service. And that's kind of a quick overview of what happens with USERRA. Now, we're going to talk a little bit about the intersection of workers' comp, FMLA, and the Americans with Disabilities Act. Individually, these laws are complicated and can be hard to understand. Collectively, it's like the Bermuda Triangle of laws, because when they intersect, you can have some serious confusion. So let's just real quick look at the differences in these, and I'm certain you all know this. Now, there are times when your employees get mixed up about these rules and these laws. If we as professionals can hardly keep it straight, you just understand how employees every employee has a sister whose husband, whose brother, whose cousin knows what the laws are and can and let you know that, but there's a lot of misunderstanding. Frequently, I found people mix up unemployment with workers' comp. So those are obviously two very distinct things. Sometimes employees will think that they are paying into funds that somehow support unemployment, workers' comp, FMLA, ADA, whatever it is, and it's not true. The employer, if it's an insurance plan like workers' comp, you're the one paying the bill for that workers' comp insurance. So as you know, that's a business insurance that provides benefits to employees who suffer work-related injuries or illnesses. So that is to cover work-related injuries, medical care, lost wages, and that sort of thing. These are governed by state law, and so there may be differences from one state to another If you have HR experience in some other state, you may come here and find that our workers' comp laws are different. And then, of course, there's FMLA, which is a federal law and is governed purely by the Department of Labor under the federal government. And that entitles eligible employees of covered employers to take unpaid job-protected leave for certain circumstances, as you know. The ADA is the Americans with Disabilities Act. That is also a federal law, which means all U.S. employers are potentially subject to falling under the ADA. There is a size limitation of 15 employees under the ADA. For Virginia employers, we always think in terms of 15 employees or more. However, Virginia has its own law, which we're going to talk about a little later, the Virginia Human Rights Act, which actually applies to employers with 5 or more employees, and there are disability rights under the Virginia Human Rights Act. So, like I say, I don't want to muddy the waters at this moment, but just to let you know that Virginia employers kind of need to set aside that 15 or more employees idea because you are likely subject to a more stringent rule than the 15 employees. Anyway, that is the federal law, and actually that's a very broad law. As human resources people, we generally think in terms of discrimination in jobs and promotions and that sort of thing of disabled individuals. But if you just also happen to wear the facilities manager hat in your company, you may also be aware that it has to do with your buildings and your accessibility and that sort of thing. That also covers public accommodations and transportation. So it's a very broad law. Right now, today, we're just thinking of it in terms of employment law and how we treat employees and applicants and that sort of thing. So what I have done is I've come up with a couple of different scenarios of how things can intersect. So the first one we're going to talk about is how workers' comp and FMLA can intersect. Okay, the employee's workers' comp absence could be due to an on-the-job injury or illness that could also qualify as a serious health condition under FMLA. So you could potentially have those two laws at work at the same time. And your FMLA can run concurrently with someone who's out on workers' comp. So if you have someone who suffers an on-the-job injury, you know how you have to file your claim with the state, or your report with the state. Then you hear from your workers' comp carrier about this particular injury. And you discover when you hear back from the employee and the physician, et cetera, that this employee is going to need to be out for 4 weeks recovering from rotator cuff surgery or whatever. At that point, you can then tell this employee that because they're going to be out for the 4 weeks, they're going to be on FMLA at the same time. Because remember, in the 12-month period, employees who are qualified have the right to 12 weeks in the 12-month period. So if you put this employee on FMLA for that 4 weeks, then that can mean that they only have 8 weeks left of FMLA for the remainder of that 12-month period. If you don't put them on their FMLA at that time, then potentially they could have 4 weeks of workers' comp and then 12 weeks of FMLA, if they had some other or some medical circumstances that required it. And again, I never like to give people the feeling that I'm Scrooge when it comes to protections for employees and that sort of thing. So I don't encourage you to try to eliminate as much of that 12 weeks a year as you can. I'm simply letting you know what the potential things that can happen if you don't have these laws kind of running concurrently. So if this employee, if you have a light duty position that you could offer this employee rather than being out on FMLA or missing work because of their workers' comp injury, the FMLA does not require that the employee accept that light duty position. Okay, you can offer it, but they don't have to take it as far as the FMLA is concerned. However, if the employee does not accept the light duty position and the workers' comp knows that it was offered, it is possible that that could cause a loss of their workers' comp benefits, the workers' comp pay benefits. It wouldn't forfeit their medical care, but it could forfeit their pay if they don't take that light duty position. All right, how about an intersection of the FMLA and the Americans with Disabilities Act? What do you do when an employee's FMLA, let's say, has been exhausted, but the employee can't return to work? I've had this happen many times. And back in the day, before the ADA came along, if that 12 weeks expired and the employee still couldn't return to work, well, you know, letter of the law said that you could probably terminate that employee's position. Now, however, that is no longer true because you have to consider the Americans with Disabilities Act. And as you all probably are aware, new cases in all things human resources are coming before the courts on a regular basis. And so things that you thought you could rely on at one point in time are not necessarily the same, you know, months or years later. So what happens with this employee who's still unable to return to work? Do not assume that you can simply run out and terminate that employee, because it's possible that the Americans with Disabilities Act could apply. And again, it depends. It depends on if the employee meets the, you know, the definition of disabled under this act. And in the last few years, there have been a couple of court cases where the employee has said and produced a doctor's note that said, if we believe that this employee can come back to work to their regular job if they have 2 more weeks off. Well, courts have held that additional time off can be considered a reasonable accommodation under the ADA. And that's why I say don't assume that you can just terminate the employee if the 12-week clock runs down and they can't come back. Before terminating or taking a negative action against this employee, you need to seek legal guidance, because you wouldn't want to make a misstep, let's say in that situation of the 2 additional weeks, or let's even say 4 or 6 additional weeks. If you tally up how much it would cost you to defend an ADA claim, a lot of times it's better to just let the employee have the additional time off, particularly if it's unpaid time, before you fire, demote, whatever you would do. And if you, before you do anything negative toward an employee in that situation, I would absolutely contact a lawyer to get guidance, you know, navigating the situation. All right. Now, what happens when workers' comp and the Americans with Disabilities Act potentially intersect? Employees who qualify for ADA and state disability laws may possibly be covered by workers' comp and disability laws both. If they meet the definition of an individual with a disability, then they will be considered disabled under the ADA, regardless of whether there's any workers' comp or anything else out there. Okay, so the ADA stands on its own without a workers' comp claim. Now, the worker must be otherwise qualified with or without a reasonable accommodation in order to be protected by disability laws. So in other words, as we all know, it's kind of like the ABCs of the ADA. The person, you do not have to hire unqualified people to fill positions, but if they are otherwise qualified under the ADA, you may have to provide a reasonable accommodation to enable them to do the job that they can otherwise perform. Now, a work-related injury is possible, might not cause an impairment severe enough to be considered a disability. Okay, so you may not, if the person has a workers' comp issue, they may not be qualified for the ADA because their injury does not rise to the level of creating a disability. All right, many on-the-job injuries are just temporary impairments, short-term, and they resolve and are not long-term. So in that case, they would be unlikely to be an ADA case along with the workers' comp case. So many of your injured workers will just qualify for workers' comp and will not be protected by the ADA. That's a thing that you work out on a case-by-case basis. And hey, guess what the last bullet point is? Seek legal help before taking any negative action against an employee in this situation. Sorry, I don't have a direct line to any lawyers that we channel people to, but it's, I mean, it is a complicated world we live in, and sometimes this is just flat out going to be necessary. All right, the bottom line, when navigating this Bermuda Triangle of employment laws, I just cannot emphasize this enough. Timely communication with the employee is essential. I know that sometimes these conversations are painful. You know, we really dislike confrontation with our employees, but kind of heading trouble off at the pass, as soon as you have a workers' comp issue or you think an ADA issue, it's good to immediately start talking to that employee about what their situation is. Document your conversation. Again, before you take any negative action, seek legal advice. And something very important with the Americans with Disabilities Act, there is this piece to that act that's called the interactive dialogue. Basically, what that means is you need to have a sit down, and it can be on the phone, or more than one, with the affected employee and have a conversation where you go back and forth about, you're asking questions, tell me a little bit about how your disability like impedes your ability to do this job. What could we do as an employer to help you, facilitate you? That's called making a reasonable accommodation. If you hit on something that you can do that does not cause you an undue hardship, then that's what you need to talk to this employee about. So you would sit down, the employee may make a suggestion and say, well, you know what, if I can't get a wheelchair into my office, if you could widen my doorway, then that would make it easy for me to get the wheelchair. And then you think about that and you're like, wow, that would really cost a lot of money to do that. And instead the light bulb goes off and you're like, hey, wait, we have another office on the other side of the building that already has a wide doorway. We would like to move you over there and life will be great. Okay, so that's the type of thing you're going back and forth to talk about how you can make an accommodation for somebody. If you really cannot come up with anything because everything that the employee needs is unreasonable because of cost, well, from a number of reasons, you may consider it unreasonable. Then again, I would seek legal advice so that you can let a lawyer help you try to figure out a way. But the bottom line there is that this interactive dialogue process where you sit down and work together to try to come up with a solution can be just as important as any other factor in handling disabilities, ADA claims. Just make sure that you don't give short shrift to that that communication, and then you want to document everything that happens and everything that you do, because it's possible you can make an accommodation for somebody that other people could also use, other employees. So anyway, it just pays to put your thinking cap on and work together to come up with an answer. All right, the Virginia Human Rights Act. This is something that some of you may not even be aware of, that this is out there. And actually, since the 1980s, Virginia has had disability protections for employees. But as of July the 1st of 2021, the Human Rights Act was amended to add additional protections for people. And by the way, there are 2 posters that are affiliated with the Virginia Human Rights Act that you are supposed to place in a prominent location. All of your employment posters that you've got, probably a wall full by now. So there's a pregnancy poster specifically, and there's a disability poster. And I'm going to send you links to both of those after we're done with this. However, I would put in a plug for the wisdom of just biting the bullet and ordering from one of the professional poster services for the state of Virginia and for the federal, and just order them. You know they're all right every year. Look at your posters and then just order new ones if you need to each year. I just think that's the easiest way to probably to take care of the poster issue. But in any case, I will send you links to these. I think there's also a USERRA poster that I didn't mention that I believe it is required, and that I'll send you a link to that one as well. So anyway, as I said before, that this act does apply to employers with 5 or more employees. And once again, just like the ADA, you must provide reasonable accommodations to disabled employees unless it would be an undue hardship. And this should be sounding familiar by now, that you need to engage in a timely, good faith interactive process with your employees. And then it mentions the poster last, requires the posting of information about the rights of employees. And now here we get a little bit different from the other posters. You need to post the posters about disabilities in a conspicuous location at the work site. It should be in your employee handbook, or the information on it should be in the handbook. You're supposed to give it to new employees when they start, and any employee who comes to you to talk about a disability, you're supposed to give that poster to them within 10 days. So that, that's quite a number of steps there that employers are supposed to go through to communicate the Virginia law on disabilities. Now, let's see, we've got several, one of the big thrusts of this disability, the state disability law, has to do with childbirth and lactation. So as of July 1st of 21, I'm sorry, you know what, my apologies. I can't believe it, I have a slide that's out of order. But anyway, let me go ahead and cover this one first, and then I'll move on to the maternity issue. This was something that we had to get clarification on that's fairly new. If you have short-term disability for your employees, short-term disability insurance, group or individual, they now have a requirement regarding maternity coverage. Now, your short-term disability policy is not required to offer coverage for childbirth, but if it does, then as of July 1st of 21, that whatever maternity coverage is covered, it has to be for up to 12 weeks in duration, okay? So that means if your employee is out having a baby, with physician approval, they would be entitled to a benefit, whatever the pay is under the terms of that policy, for 12 weeks, all right? And you can't enforce and eliminate, or they can't enforce an elimination period, which means, like, the first 2 weeks you have to use your paid leave or whatever. It starts from day one. Now, if the employee has already used some short-term disability benefits during the benefit period, then they might not be entitled to that entire 12 weeks. So if somebody was out with, they had their appendix out and they already used their STD for 3 weeks in the same benefit period, then you could deduct that from the 12 weeks and only give them 9 weeks. And again, this is the dollar amount coverage that the insurance pays. Pre-existing condition limitations may apply. So if some new employee starts with you and she's due to deliver in 2 weeks, she may not be eligible for this short-term disability benefit. And your STD carrier should be able to answer any questions that you have about that. All right, so my apologies, that seems like a little interlude there. Back to the Virginia Human Rights Act. Okay, protections from discrimination. So once again, we talked about the 5 or more employees in a 20-week period must provide reasonable accommodations for pregnancy, childbirth, or related medical conditions, including lactation, which I'm sure you all know means breastfeeding, unless the accommodation would impose an undue hardship. Now remember, if you have an employee who asks you for this accommodation, do not take any adverse action against that employee. Do not deny employment or promotions. or require an employee to take leave, which means like, okay, you've told me that you're pregnant. What you're going to do is for the next 7 months, you're going to need to stay at home with no pay. And after that baby's born, you can come back to work. Now, if there's some other reasonable accommodation that can be provided, if you can't make the person take unpaid leave or paid leave. Just an hour before we started this today, I found a case that doesn't have anything to do with disability, but it does have a case, it does have to do with employers taking foolish actions against employees when they ask or do something that is legal, and then you want to punish them for it. And this case was, I do not remember where or the name of the company, but an employee reported to their supervisor that there were unsafe COVID, they weren't taking proper COVID precautions, and it was some type of security company, and that the weapons in the security company were not properly secured. Just with the supervisor, they told this information. So within 10 minutes, the employer had basically emailed the employee to tell them they were fired. Can you imagine? So this is like a public policy issue. The employee puts the employer on notice that you've got a couple of unsafe situations here, and so you get fired for that. Okay, so as you might imagine, the employee filed suit, and as you might imagine, the Department of Labor said, this is a pretty good case. And so now now the employer is in hot water. It has not been resolved yet, but it's in the works. So you know that if your employee comes to you and asks for ADA accommodations, if they ask for FMLA, if they ask for any legally protected right, you do not want to take negative action against that person. Retaliation, believe it or not, is now the EEOC's #1 reason for employees filing suits against their employers. Retaliation, getting back at somebody for doing something. So anyway, that retaliation is never a good idea, and that retaliation can kind of be real or imagined. Okay, so even if you didn't mean to retaliate against an employee who just came back from FMLA leave and 2 weeks later you fired that person, it's like the proximity of the termination to the FMLA leave is surprisingly suspicious, and the employee could very easily perceive it as retaliation. But again, lest employers become fearful of everything, you're probably not talking about a situation, let's say while the employee is out on FMLA, you discovered that they've embezzled $50,000 from you, that you would be afraid to now fire that employee. That would be probably a different story. I would still get legal help navigating that, but anyway, you can see that there would be some instances where it would absolutely not be retaliatory. But do remember that employees are extremely sensitive to employers retaliating against them. Okay, now what type of accommodations can you give to someone who is pregnant, who has come back from childbirth, who is wanting to pump breast milk? These are deemed to be reasonable to allow your employees to take frequent or longer bathroom breaks. If you've ever been pregnant, you know sometimes that's a necessity. Breaks to express breast milk. They don't have to be paid breaks, but if you do give paid breaks, twice a day you get a 10-minute break, the employee does have to be allowed to use that regular break to go pump. You must provide them access to a clean private location other than a bathroom for the expression of breast milk, and it needs to have a locking door. Now, this does not mean that you have to set up a lactation room permanently. What this means is that when you have an employee who is pregnant, at that point you can designate their room and give them the key and let them know, or whatever, communicate to the employee before they go out, would be my suggestion, that, hey, this room is available for your use, and you keep it available for as long as that employee needs it. Actually, you know what? I don't believe Virginia has now a maximum period. My apologies. I think this federal law says that you do this for 12 months. The employee can pump breast milk for 12 months. I don't believe Virginia has a 12-month limitation. But anyway, you make certain, yeah, another reasonable accommodation would be to make sure that the employee has seating and to make sure that it's comfortable seating. Also, a reasonable accommodation, temporarily transfer that employee to a less strenuous or less hazardous position, or provide them with some assistance with manual labor, like lifting heavy objects, restructure the job, modify the work schedule, throw some light duty in there, and provide leave time to recover from childbirth. So those are not just friendly suggestions. Those are things that Virginia says are reasonable. So what is an undue hardship? Always these type of things are hard to define. And a lot of times the law does not specify what it means. But here, in order to look at your own situation and say, hey, is that an undue hardship? Consider the nature of the operation, consider the size of your facility, consider the nature and cost of the accommodation needed. So all of those things go into deciding, for a large company, let's say a call center that has 200 people sitting in a room answering the phone all day, it would probably be easier to accommodate women coming back or being pregnant. If somebody says, could I work part-time for the next 4 months, it would probably be easier to accommodate that in a company that's got a lot of people in the same position. Whereas if you are a small company and you have 10 employees and somebody wants to take every Wednesday and every Friday off, and she's the only person that's in that position, that can be harder to accommodate. It doesn't mean that you can't accommodate, but that last sentence there is the important thing. You still sit down and talk to the employee and you go back and forth about this and just see if you can't come up with something that would help the employee, but at the same time does not put an undue burden on you as an employer. So once again, the reiteration that almost as important as the accommodation itself is the discussion of the accommodation. I'm starting to sound like a broken record here. Seek legal advice before you take any negative action. Timely communication with the employee is essential. Good documentation of the situation is equally essential. And seeking advice on any of these laws, particularly when an employee has exercised a legal right under any of these protective laws. You just don't want to incur the expense, both in time and money, of making a misstep and then having to correct things. It's something about a pound of cure. An ounce of prevention is worth a pound of cure. I think that's the old adage. Now we have a couple of just brief North Carolina updates, and I don't know if we have any clients that are in any of these districts, but several North Carolina localities have enacted laws prohibiting certain types of discrimination. So interesting, when I think that I've been in human resources since 1982, and that generally back in the day you had federal human resources laws, and that was pretty much it. I don't recall much, if any, in the way of state laws. Then gradually states started coming up with their own HR laws, and now we're down to localities. So, in some localities, even in Virginia, let's say, I believe their minimum wages in Northern Virginia, some of the cities there have their own minimum wage. So anyway, in North Carolina, in the Charlotte area, you can see that there is no discrimination allowed on the basis of gender identity, gender expression, sexual orientation, and natural hairstyle. In Winston-Salem area, prohibits discrimination in employment and public accommodations on the basis of the protected class. And I'm not sure, my apologies, I'm not sure exactly what protected class that is, but I'm assuming, I think it may be the same thing as the Charlotte ordinance. And then in Wake County extends protection to gender identity, gender expression, sexual orientation, and natural hairstyle. So if you work or have an office in any of those locations, you might be aware of that. Just kind of those new protected classes. All right, so now we're going to move out of the kind of HR laws, and we're going to move into, I think maybe this is where the potpourri comes in, that I get questions on CMS and the Medicare Creditable Coverage Notice. And I'll be honest with you, when I was still in HR actively, 15 or 20 years ago, I can remember kind of scratching my head over this. What is this that we have to do? So just to inform you, many people are working past the age of 65 now. And Medicare, when you go into Medicare, it has multiple parts to it, but your employees who are over 65 have got to be enrolled in a drug plan that offers benefits that are as good as the Medicare Part D benefits. And if they don't, then they will get a penalty when they eventually move off of your plan and go full blown into Medicare, okay? So each year, your carrier should provide you with a notice that's called the Creditable Coverage Notice. And it should usually a one-page notice, and usually one notice for each. If you offer 3 different kinds of plans, it should be one for each plan that says whether or not that plan is creditable, okay? So basically, it protects your over 65 employees, but our recommendation is to just get that creditable coverage notice and just send it out to all your employees, okay? Just send it to everybody. And that way you're covered, you don't have to track who's 65 and who's not, et cetera. By October 15th of each year, you're supposed to send that credible coverage notice out. And then you have to go online to CMS, which is the Center for Medicare and Medicaid Services. Within 60 days from the beginning of your plan year, you need to go online and confirm with CMS that you did in fact send that notice out. So if you were wondering what that notice is all about, hopefully now you understand that it has to do with Medicare and has to do with helping make sure that your employees do not incur penalties for not having coverage that's as good as Medicare's coverage. All right, don't you just love initials that are not pronounceable and don't spell anything? If you have never heard of a QM-CSO or an NMSN, consider yourself lucky. This is something for some reason, and I don't know if the pandemic had anything to do with and the fact that people are moving around jobs or whatever, but I think I've gotten 3 or 4 questions about these things in the last year. A QM-CSO is a Qualified Medicare Child Support Order, okay? What the deal is, the purpose of these initials is they describe requirements that there's a push to make sure that everybody has health insurance coverage. And this is specifically geared to making certain that children have health insurance. And so you may get this big form in the mail that's actually going to be 6 or 8 pages long. And it's going to boil down to saying to you, the employer, you employ somebody who has a child that needs health coverage. And a judge has signed this notice. And what you've got to do, employer, is you have to enroll this child onto a health plan because you employ their parent that is required by law to provide such health coverage. All right, so you look at this big document and you try to weed through what am I required to do. And I'll be honest with you, it's very repetitive and it's sort of hard to understand. And the inclination might be to go, well, Joe Smith does not have health insurance with us, so I'm just going to ignore this. You can't ignore it, because if Joe Smith is your employee, even if he's not on your plan, even if he isn't eligible for your plan yet, you still have to fill out this form, and you still have to comply with the form. So you'll get this thing in the mail, or usually by email. You're going to need to read through it, figure out what you're supposed to do, It's got all the contact information that you need on there regarding the agency that sent this thing to you. You're going to want probably to call that agency and say, okay, I've got this. Now please tell me step by step what I need to do with it. I've had to make that call a couple of times, and I've found these agencies to be very cooperative and very much want to help you get through it. So that qualified medical child support order is something that okay, you got two parents, right? Something that the parent that's working with the lawyer drafts the child support order. It goes to a judge. The judge signs it. Then it goes to the employer. The National Medical Support Notice, instead of a parent and a lawyer kind of working together to initiate one of these things, you've got some state support enforcement agency that's working on behalf of the child. They issue their own order. That's a National Medical Support Notice, okay? But they fulfill the same role. They are for the purpose of getting your children or a child enrolled in health insurance. All right, so here we go. Both are vehicles for providing health coverage for dependent children. Explains the difference. One's the court order signed by a judge. The other comes through an agency that's acting on behalf of the child. But they're usually known by those two sets of initials. Now, you as the employer, what do you have to do? Number one, do not ignore it. You could possibly incur liability if you don't comply with the order, which you don't want to do. Believe it or not, if you had an employee that opted out of your health insurance, you may end up being required to enroll that employee into a plan for which he or she is eligible, so that the child can be enrolled in the plan. You're only required to enroll the child in a plan that the employee is eligible for. You don't have to create any special rules or any special categories or anything. You have to go with what the employee is eligible for. You absolutely must not punish or terminate any employee just because you got that order. Then you have to comply with it. And you should call the issuing agency if you have any questions. My first piece of advice would be to read through the whole order, okay? Take it, read through the whole thing. And like I said, it's often repetitive. Then kind of write out action steps that you're supposed to take. It'll tell you what to do. And you are the one that decides if this order, if you have to comply, I'm sorry, there's a special term for the order. Qualified. Thank you, Corbin. She's here giving me hints. If the order is qualified, you're the one that has to decide. So for example, if that employee does not work for you anymore, there will be a section on the order that you can check a box and say no longer works for us and send it back. So that therefore it would not be a qualified order. If the employee works for you, but let's say is not eligible for benefits, so let's say that employee only works 20 hours a week and is not eligible, well, then that order is probably not qualified. If they're not yet eligible, now this order will turn out to be qualified at some point if the employee continues working for you, but you don't have to enroll anybody before the eligibility date of the employee. So go through it, read it, write out your action steps, kind of formulate any questions you might have, and then call the agency to fill in the gaps for you. And truly, once you have overcome the shock at the length of this thing and how complicated it is to read, it really is not that difficult to follow. Obviously, you might not have a happy employee over all this, but there's not anything that you can do about that. You have to follow the law. All right, another little bit of potpourri, just some thinking about handbook updates that you might want to think about. If you are back in the workplace full-time, all of your employees are back, you may think, well, I don't need a work from home policy, and that may be true. However, if you can foresee some places where, this working from home thing for a lot of people has been really handy. So if you could see some potential, although everybody's back in the office right now, however, if we had somebody who was out on medical leave, heck, they could just take their computer home and keep working. So you may want to have some type of work from home policy that spells out under what circumstances an employee may be able to work from home periodically. You may make sure you have qualified statements in there about, nobody, we don't consider this a viable alternative work plan on a day-to-day basis, but with certain exceptions, you may temporarily work from home. Has to be approved by HR, your supervisor, et cetera. You still might need a COVID vaccine policy, even though, in recent days, it seems like we're all dancing in the streets because the pandemic looks like maybe it's waning and, people are shoving off the masks and all that kind of stuff. You can still require your employees to get the vaccine, though. I'm going to go over these vaccine mandates in a minute, but some people are still going to be required to get vaccinated. And so anyway, you just might want a written vaccine policy. You might want a parental leave policy. This gets into a little bit of complicated territory. We always, traditionally, I'll say, we have thought in terms of maternity leave, right? Sometimes we have sick leave or medical leave and maternity leave. We really need to shift our thinking about parental leave, because you have two issues when you have a maternity situation. First of all, you've got a pregnant woman, and pregnancy is a medical issue, okay? So for the pregnancy part of a leave, you may have a pregnant employee who would be out on some type of medical leave for normally 6 weeks. That's your typical, medical duration. But then she might want to stay out for another 2 to 6 weeks, bonding, recovering further, et cetera. And an FMLA now does not make any distinction between the medical part and the bonding part, okay? Men and women get 12 weeks of FMLA for childbirth or adoption, period. But if you have a situation where you're not an FMLA employer, let's say you're under 50 employees, and you need to come up with some type of leave time, the woman during the pregnancy should be treated just like any other person with a medical situation, okay? So if you allow employees to be out for 6 weeks to have a heart transplant or to have, their appendix out, then you would let the mother have that same 6 week period of medical leave. And I'm not talking about paid leave. I simply mean leave of absence, time away from work. Now, bonding time that is not medical, we should not think any longer in terms of maternity, paternity, okay? You should have, if you're going to offer any type of leave like that, it should simply be parental leave, and it's the same duration of leave should be available to the mother and the father. You should not discriminate on the basis of the gender of the parent. All right. So that, again, that doesn't mean you have to pay them or should pay them. It simply means that the time off should be offered to both parents, and that's just the bonding type of leave, not the medical leave that the mother experiences during pregnancy and childbirth. Okay. So I know that may be confusing, but I'm happy to say more about that. If anyone has a question about that, my email is going to be at the end of this thing. You're free to email me. Sometimes you have to go away and think about that for a couple of minutes and figure out what would be a good policy for your company. So anyway, that might be something you might want to consider. And once again, don't forget to take a look at your required posters. And I would emphasize that the easiest thing to do might be to simply go to a poster company and buy some posters, because they do make them state specific. All right, potpourri and more potpourri. More random topics. You are all probably aware now that group and individual health plans must provide your employees with over-the-counter COVID tests. And that was effective 1/15 of 22. So that means that you don't have to, no doctor has to be involved, no healthcare provider has to be involved. You can simply order them. I ordered some yesterday, as a matter of fact. You all can get eight tests per member per 30-day period. So that means a family of 4 could get 32 tests per 30-day period, not knowing why you would want anything like that. But it is true that sometimes if one person in the family tests positive, then everybody might want to use a test. So you can see where it would be reasonable to say we want more than one test. But anyway, those are the parameters. There is no cost sharing for this. There's no deductible, no copayment, no coinsurance. These things are either going to be free at the point of sale if the provider participates with the health plan, or members may be reimbursed if using a non-participating provider. Just yesterday, I believe, we published something, we sent a blast out to our clients that where it outlines many of the carriers and what their policies are. So that information is now out there, that most of the carriers have published, how their programs work. These are for personal use only, and they're not used for employment purposes. So if you have somebody at work, you can't require them to use their at-home test to prove to you that they're COVID-free in order to enter the workplace. All right. I'm sure you all know this by now. In Virginia, our minimum wage is now $11 an hour, 1/1 of 23. At this point, it will go to $12 an hour for most employees. Okay, now just to, vaccine mandates occupied a very large space in the news media for a couple of months. Just to let you know where everything stands right now. OSHA, that was the big one that everybody was so concerned about. Over 100 employees you had to mandate vaccines. That is stayed for now. It's possible that the emergency temporary standard that OSHA created may turn into some type of permanent standard, or they may use it as a basis. But for right now, we don't have to worry about any vaccine mandates regarding OSHA. But don't forget that as an employer, you still have what's called the general duty clause for employers to provide a safe workplace. Okay, so don't forget that. Frankly, I wouldn't just cast off everything to do with COVID right now. You still need to follow the state laws, and you still need to exercise care in your workplace, like providing hand sanitizer and PPE where necessary, mask, or require masking or that sort of thing. But the mandate for the vaccine is gone. The CMS, Center for Medicare and Medicaid Services, their vaccine mandate for healthcare workers, the Supreme Court allowed that to stand on January 13th. So that means that certain healthcare workers are required to be vaccinated. And our Virginia schedule, I love this. The schedules are in 3 groups. There are like 24 states that objected. They have one schedule of compliance schedule. There were 25 states that did something different. They have a different schedule, and Texas has its own schedule. I'm not sure why, but anyway, it's just almost, it seems like the point of absurdity that these vaccine mandates got to. But anyway, these dates are going to roll around here soon. So Virginia is you're supposed to have the first shot by the 27th and the second by the February 28th. And again, that's just for specific healthcare workers. And there's the list. If you Google it, if you want to know, the exhaustive list is out there in many places. Then we still have the Executive Order 14042, which was called the Vaccine Mandate for Government Contractors. That is on hold right now. It's still working its way through courts. Maybe as the vaccine wanes, that'll become less of an issue. But anyway, for right now, you don't have to worry about complying with that. But it hasn't gone away permanently. It's like a zombie law, right? It's not exactly dead, but it's sort of dead. All right, BOL, be on the lookout. As you might be aware, if you have both exempt and non-exempt employees, Exempt employees who are not entitled to overtime have a minimum salary that they must be paid in order to fall into the exempt column. Just be aware that there has been talk of increasing that minimum salary requirement in 2022. Okay, hasn't been done yet, but just be aware that that might be one of those things that you need to deal with later on in the year. Corbin, would you like to say a little bit to us? Would you like to come around? We're in, yes. By the way, we're in a new setting. We have moved downtown to, now it's the TowneBank building.
Yes.
At one time was the Norfolk Southern building, and that's where we're broadcasting from, the lovely 16th floor. But we're having to get used to all sorts of different equipment. So hopefully you've been able to hear me and see the slides, and everything looks normal from here. But anyway, Corbin's going to step in here.
Yes, and Barbara, you and I have sort of been celebrating because it really was almost, what, a year, 2 years since we've really been in the same room and broadcasting together and
yes, it's been
being able to do these things together. So for everyone on the line, if you haven't interacted with Barbara, she has really increased my team by 100%. And even more because she specializes in more of the employment and HR side. And I sort of stay in my little lane, which is around, the Affordable Care Act, ERISA, HIPAA, and stuff like that. So between the two of us, we like to team up together and handle different topics. And so we thank you guys for listening to us today.
Very much.
Very briefly, as part of the American Rescue Plan, which you may know, it really, the legislation made some substantial changes in terms of the Affordable Care Act and available subsidies. And really, what it did is it not only increased the income cap to be eligible for subsidies, it really did eliminate what we used to call the subsidy cliff. So as someone, and it's all based on how many individuals are in the family applying for coverage. And then as you got closer to what was considered 400% of the federal poverty level, which I think for one individual hovers around 48,000 or so today. Once you hit that magic 48,000 number, then you hit the subsidy cliff and you could not receive any subsidy whatsoever. Now, while you have higher income individuals, the government has actually, or the marketplace has actually made a cap of their premiums are capped at 8.5% of income. That would be for your second lowest silver plan, and then the government would make up the difference between the 8.5 and the actual coverage cost. So that has been extremely popular. The marketplace opened up a special enrollment, what they call SEPs, and they offered opportunities for individuals to enroll again. And the only cautionary tale I would tell about this is for any client on the line who is an applicable large employer, you may have had individuals who waived coverage even though you made an affordable offer, and they may actually have obtained a subsidy on the marketplace during this special enrollment period. The emphasis has really been on attaining enrollment numbers, and sometimes the marketplace does check and ask for verification, but just be aware that not only was the marketplace attractive before, especially to lower incomes, it has extended that at least through 2022. Now, it will take more legislative action for it to continue past 2022. If history is any guide, it is difficult often to expand a program and then to virtually take it away. So we shall see what happens with that. But again, the subsidies were increased through 2022. Next slide. Surprise billing law. All right, so this has been, balance billing has really been a difficult situation for so many families. I think they represent balance billing where you're billed even more than what your network provider would pay because you happen to see an out-of-network provider in an in-network facility. So you thought everyone was in-network, but then you received a balance bill. And I think there was an estimate, something like 13% of emergency room visits resulted in balance billing. And so I'm going to touch very briefly on two balance billing laws. First is Virginia's balance billing law that became effective last January 1, 2021. And then I'll speak to the federal law. The Virginia balance billing law basically covers any services from an out-of-network provider. It pays as if an in-network provider if you get the services of an out-of-network provider at an in-network facility. So for example, let's say you are taken to the hospital and you need emergency services, and the hospital is in network, but they bring in an anesthesiologist that happens to be out of network. Well, you cannot be balance billed for that situation. There is a huge limitation to the Virginia plan, which is that it only relates to Virginia regulated managed care plans, or what we would call fully insured plans. This does not apply to self-insured plans, what you may refer to as balance funding or level premiums, unless the plan chose to opt into the law. Now, at this point in time, I'm not aware of any plan sponsor that chose to opt into the Virginia law, simply because that could have increased claims cost and could have impacted the ultimate experience of the plan and impact rates. So Virginia has that balance billing law, and effective January 1 of 2022,
Is that right? There we go.
we passed on the federal level as part of the Consolidated Appropriations Act. A law was passed called the No Surprises Act, and there were also transparency and health coverage rules. Now, the No Surprises Act is a really large piece of legislation, and there are many, many other parts to this. And we intend to be doing a webinar probably in April as the rules and regulations are being fine-tuned with respect to that, even though the provisions came into effect, many of them January 1. So just want to briefly touch on this today, which is this Balance Billing Act. First thing to tell you, which is most important, is this applies to both fully insured and self-funded plans. So unlike the Virginia balance billing law, the federal law will cover cases of self-funded plans. So there may be cases where the Virginia law really applies, and then other situations where the federal law applies. Not only it provides protection for balance billing from out-of-network providers for certain emergency procedures. And I think one of the greatest components of this law, and hopefully no one, or you do not know anyone who's had to use this, is there are no longer any out-of-network air ambulance charges. So when an individual is at the most vulnerable, perhaps it's a skiing accident and they're on the slopes and they need to be airlifted out, nobody's going to ask, are you out of network or in network, and what's the fee going to be? And the area ambulance charges were getting pretty egregious. I mean, even north of $20, $30, $40, $50,000 in some instances. And so this was a situation that had to be regulated on the federal level. So it does not apply to ground ambulances, but should you ever need, or any of your family members ever need, an air ambulance service, that will be covered as if it is in network. So for emergency services, it would be covered in network, and it also provides protection for non-emergency care at certain in-network providers. So, for example, and there's certain labs, or there's certain entities or services where they cannot opt out. So for example, emergency medicine, pathology, radiology, neonatology, and diagnostic services such as radiology and lab services cannot be handled as if they're out of network. So you may go to an urgent care center that is in network, but again, perhaps they send things out to an out-of-network lab. That should no longer be an issue, irrespective of what plan you're on. Now, again, this is a really brief overview because there are certain cases where you as an individual can agree to be balance billed if certain conditions are met, if you're given notice and you accept the balance billing charges. But we just wanted to mention before our webinar in April that there not only is this provision of the No Surprises Act very important, but there are many, many other issues that have really helped consumers with respect to transparency and cost. So,
all right. So
yeah.
Those two laws are very similar.
Yes.
But this one is the more comprehensive, is that right?
Yes.
Because it covers everybody, or every.
Yes, it covers everyone, fully insured, self-insured, and it goes farther. There may be cases where the Virginia law applies,
right?
But in many cases it'll be the federal law, and the federal law. If an out-of-network provider doesn't want to accept the payment, you can go to what's called an independent dispute resolution process. Right. And there are also other provisions of the law with respect to getting an advanced explanation of benefits,
right.
Provider directories being up to date, also protecting someone's continuity of care. So if a provider leaves the network and maybe you're in cancer treatment and that provider has left the network and it meets the terms, you can be, your care just can't be discontinued and handled on an out-of-network basis. So I would say this law and the transparency and coverage rules really do a lot in terms of patient protection and also related to cost.
Good for the consumer, good for the non-expert. Yes. I think that's what the big problem is, when you're not an expert and who is in medical billing. Right. It really be damaging to people.
And even though we're in the business, sometimes it's hard to read and understand the explanations of benefits, or
so true.
The communications that they send to you. So,
well, thanks so much, Corbin.
Thank you.
We are at the end of our presentation. If you have questions, I did not go over questions at the beginning. I hope you have felt free to enter. I'm sorry.
Yes, we have some.
These are the resources, some of the resources that I rely on. I included them, and first I would put in a plug for the for SHRM. I would highly recommend that you join SHRM. I mean, you talk about a wealth of information, and honestly, the annual membership fee is not that onerous at all, and what you get for that is amazing. I mean, literally not a day goes by that I do not go to their website for some purpose, because I've gotten some question. Then there's this website called JD Supra. What you do there is you've got a bunch of law firms that join this organization, and their opinions and their writings and stuff get put into put online so that you can search and find out all sorts of topics through JD Supra, all written by lawyers. NOLO is similar. I use NOLO a lot for finding out state-specific rules and laws, and then a newsletter called HR Daily Advisor that's free, comes in every day to my inbox, and they have regular podcasts and that sort of thing that also can have some handy information. So I'm going to go to the questions now and just see if I've had anyone to ask a question. Oh, we did.
Stop sharing the screen.
Yes, you can do. I'm sorry, I'm technologically challenged.
There we go.
Good. All right. Okay, so I had a question that's, so employers cannot ask a person who just had a baby to take their PTO if they want off with pay. Okay. I'm not sure if you're an FMLA employer or if you're too small for that. If you have to comply with FMLA, my suggestion is you as the employer can set up your policy on how people are going to get paid when they're out on FMLA, or if they're going to get paid. Okay, so you create a policy, and then you put that in your handbook, and then anytime you have somebody that's going to be out on FMLA, whether it's to have a baby or just for other medical issues, you go over with them how they're going to get paid, and you can dictate that employees must use their paid time. Some employers may offer the option and tell employees, if you want to use your paid time off, you can, but we're not going to make you. So really, that's completely up to you. Once you have made a policy, then you want to apply it to every similarly situated people. You want to apply the same standards to people who have the same or similar situations. So if you've got a man who's going to be out for a medical issue under FMLA, and then you've got a woman who's going to be having a baby, all of those are medical situations. They should all be treated consistently. Inconsistency is a real problem in HR. All right, if you're not an FMLA employer because you're too small, then you don't have to worry about the 12-week limitation and all that sort of thing, but you still should come up with your own policy about how much time you will allow people to be off, how long will you hold people's jobs. Again, it should be applied consistently to all applicable employees. It is possible to discriminate between classes of employees with some benefits. So for example, you could tell part-time employees that they don't get paid for holidays or that they don't accrue medical leave, whereas all your full-time employees would get those benefits. But you come up with whatever your medical leave policy is. So if you enable people to accumulate 1.5 days a month of PTO, and it can be used for any absence, and if they're out on medical leave, then you're going to make them use their PTO, that sort of thing. Think through your policy, develop it, put it in writing, put it in your handbook. Then when someone needs it before they go out, explain to them what happens while they're out. I find that I do get questions from employers sometimes that are after the fact. Oh my gosh, this employee has now been out for 3 months, and we've been paying the insurance premium, or we're not sure if they're going to come back. Do we have to pay them, that sort of thing. Get all that squared away before the person goes out as much as possible. And that way, it's way better not to have any surprises if you can do that. I got the question, any chance this is being recorded and would be available? You know what?
It automatically record.
Okay, good to know. Yes, it's been recorded, and what I know that somebody has to work some magic with it before it's ready to be put out there, but it should go out eventually. I'm sorry, not eventually. I think it might take a week or so.
And we'll send it with the slide. We can send the link with the slides. to anyone who registered. That's typically
Right.
what we do.
Yeah, exactly. And as you know, I said I've got some links to send you for the posters and that sort of thing. Question: how long would you need to make let's say a light duty position available? This is one of those questions that there's really not a firm answer to, because number one, you may not even have to make any light duty accommodation for somebody. I mean, that might not be reasonable. Again, depending on the size of your company, how many people you have in that position, et cetera. If you may not have any light duty positions available either. You know, there might not be any such thing in your company. So the important thing is, if you're talking about a disability, you need to sit down and talk to the person about what they need in terms of an accommodation. If they throw light duty out there and that's something that you can do, then heck, you can accommodate their number one, on their wish list. If they say something different that would be a hardship for you, you could always come back and say, hey, you know what, we have a light duty job available. How about that? You can go back and forth about what might work. So it's going to be very individualized in terms of what type of accommodation you're going to be able to come up with. The big thing there is going to be, before you walk away from the table with that employee and you say, there is just nothing I can do for you, I would talk to legal counsel before I get to that point, and let a lawyer help you navigate. If your only choice is going to be to fire this person, to let them take off, without pay for 3 months, I mean, that could be reasonable. We'll hold your job for 3 months with no pay, and we'll pay your health insurance premium. There's just no hard, fast rule about the accommodation issues. And so, but the important thing is, before you get to that point of taking a negative action, talk to legal counsel.
May I make one comment, Barbara? Because one of the things that we run into as you're guiding employers in terms of making their medical leave policies consistent in FMLA is often employers, in trying to assist an employee, they will allow them to take off, be on leave, but they keep them on the policy. Sometimes we've seen 6, 9 months, maybe up to a year. And, really you think to yourself, well, what is the problem with that? Well, the problem with that is every insurance carrier has a rule which says the employee must be actively at work. And they have exceptions to that rule, and they can vary by carrier. So for example, if you're an FMLA eligible employer, it might be, 3 months or 6 months, right, with an approved leave. But what you don't want to have happen is keep the employee on as if they're active when they no longer meet the qualifications of eligibility by the insurance company.
Right.
You would want to offer them COBRA. And the reason for that is, if you're audited, and especially if you're a self-insured plan, and perhaps the stop-loss carrier or the carrier audits you, and they find out that this individual has been on the plan months and months and months past when they should have been, and claims have been paid, the insurance carrier has the right and will refund the premiums, but then request repayment of the claims. So in trying to be the good guy and in trying to help, everyone is actually in a worse situation.
Right.
So when you have those kinds of questions, let us know, let your broker know, and we're happy to guide you through that process.
Right. I think it's safe to say that for health, dental, and vision, it's not, the actively at work requirement is not going to be any less than 90 days.
Right.
Because FMLA covers those. But anytime you start getting into territory beyond 90 days, definitely the carrier needs to weigh in on.
Right. Yes.
On it. Sorry, we've lost control of the mouse.
Yeah, you know how you put it, right? You put it, just turn it. You know, you put it on the keyboard. Why?
I know, I don't know why we're having this issue.
Okay, I'm getting close. Can you know what? Maybe you can do it while he's doing something. It's a good thing we weren't in charge of the moon landing.
That's for sure, because Houston, we would have a problem. That is so weird. I've never.
Can you click on the gray area, maybe?
Oh, here we go.
Yeah.
Oh,
We can.
the geniuses have figured it out. Okay. Okay, let's see. We had another question. Sorry, I'm trying to line it up on the screen. I mean, I need to be doing that.
Okay.
Teacher who says she can't come back to work for, okay. I have a teacher who says she can't come back to work for an additional month after pregnancy. If she is the only teacher for that grade and substitute teachers are scarce, could that be an undue hardship? Possibly. But again, that would be one of those things where before you say no or before she quits in a huff, I would explore if there are other, well, is there any other option? I think I would seek legal help before I would let anything negative happen with that employee. Because yeah, that is true. That certainly human resources can create an undue hardship if you literally have to, you don't have a very few alternatives to what the person is asking, then it could very well be an undue hardship. But I would, yeah, I talked to a lawyer before I'd let the person go or let her walk out the door. We defined balance billing. Hopefully that was a good explanation.
I should have said please define.
But you did.
Oh, we did.
You did define it.
Okay.
Do you know if North Carolina has a balance billing law? The federal law would cover that?
Correct. So we've gotten a couple of questions if which state has a balanced billing law. But again, remember the federal law is more expansive in that it covers both fully insured and self-insured and also covers air ambulances. So if you are in a state that does not have a balanced billing law, the federal balanced billing law would apply.
Okay. All right, will we be getting a copy of the presentation? Yes, and it probably won't be today, but yeah, the next day or two, I will get that out to everybody. And hey, you two are absolutely awesome. Thank you so much. I assure you that if you can see that statement, we did not pay anyone to say that. No, it's really our pleasure to do this. Truly, it feels so good to be kind of talking about HR on a more global terms than COVID. And I hope that everyone who hung in there to the end got something out of this. You have our email addresses, or you will have them when we send you the copy of this presentation, and hope that you have a terrific rest of your afternoon. And thank you so much for being clients of our company, and thank you so much for participating today. We really hope that you picked up at least one good thing that made it worthwhile for you to join us today. And hope to see you again soon. Thanks so much.
Thank you.